Thank you very much indeed.
Thanks, Graham. Well, good afternoon, ladies and gentlemen. Thank you for that introduction, Graham. Since I've got the graveyard slot this afternoon and I'm not using IT, although a copy of my notes will be on the Shelter website, I thought I'd start off with a quiz. And the title of my talk this afternoon was really going to be "The Past is a Foreign Country, They Do Things Differently There." And that certainly applies to the Sheriff Court after this new legislation. "The past is a foreign country, they do things differently there" was the first sentence of a book by L.P. Hartley. And I've got a magnificent prize here for the person who can tell me the title of that book.
Fly fishing on the way to the last tree out.
Don't hang your hand up, please. Right.
Correct, sir. Very well done.
Is he allowed to open it now, Eric?
Open it now, yeah.
You can open it now.
Well, ladies and gentlemen, the Homeowner and Debtor Protection Scotland Act 2010. There are two main implications for the courts. One is in relation to court actions, and the second is in relation to lay representation. To deal with court actions, first of all, Section 2 of the Act provides that all applications in terms of Section 24 of the Conveyancing and Feudal Reform Scotland Act 1970 for the recovery of property, and Section 5 of the Heritage Scotland Act 1894 for ejection, shall be by summary application and therefore call in court on a fixed day at a fixed time. As repossessions actions do not currently call in court, the Act will have an impact on resources and court time for the Scottish Court Service. In planning for the impact of the legislation on the Sheriff Courts, we have anticipated that repossession cases will increase in the next year, then falling off before steadying in the years 2012 to 13. We have estimated that the courts will require 190 additional court days for 2010 to 2012, dropping to 120 additional court days for 2012 to 13. However, the full impact is likely to be felt only in the larger courts. We anticipate that only 8 courts will face time increases of significantly over 1 hour a week, with Glasgow, Edinburgh and Hamilton having an increase of between 4 to 6 hours a week, and of the remaining 5 courts an increase of around 1 to 2 hours per week. Of the remaining 40 courts or so, 7 dealt with less than 8 mortgage lender actions a month, and the remaining 34 dealt with 5 or less such actions a week. The time increases in those courts is likely only to have a limited impact, with the majority of courts facing time increases of around 10 minutes a week. So it's really only the bigger courts that are going to be affected by this. It's hoped that the number of cases and the estimates of around 50% of defenders appearing is at the high end of the scale, but even if only 25% of cases have appearance by the defender, taking account of the impact of lay representation, it is expected that court time will increase significantly. The Act of Sederant, Sheriff Court Rules Amendment, Homeowner and Debtor Protection Scotland Act 2010, to give it its full title, is still to be finalised. That's the Act of Sederant which will regulate the procedure and forms in the Sheriff Court. However, without giving away any secrets, I anticipate that the Act of Sederant will state that the pursuer must lodge a form certifying the completion of pre-action requirements, and Gavin talked about that earlier today. when the initial writ is lodged in the Sheriff Clerk's office. So along with the writ there will be some kind of tick list that pre-action requirements have been carried out. The rules of court will also contain provisions that deal with intimation to non-entitled residents, application to the court by entitled residents, and provisions relating to recall of decree. The Secretary of the Rules Council advises me that the Act of Surveillance will be finalised sometime in August of this year. Now, turning to lay representation, paragraphs 5.3 to 5.14 of the Repossessions Group final report recognised that the repossessions process, in particular a court appearance, can be intimidating for homeowners faced with a repossession. I suppose court appearances can be intimidating for anyone, and having worked in the courts for 38 years, it's a thing I found difficult to understand how anybody could be apprehensive of appearing in court. And I was speaking to a friend of mine in the health service and saying how I hate going to hospitals. And she said, well, it's just the same for me going to your court, Eric, as you coming to my hospital. It's the fear of the unknown, I suppose. Anyway, the Repossessions Group highlighted that court can be an intimidating place for people facing a court action. To tackle these issues, the group recommended that there should be a statutory change to enable homeowners to have the option of being represented in court by approved lay representatives as well as solicitors. This would make the court process more accessible and encourage more people to take advantage of legal protection on offer. Section 7 of the new Act allows for the debtor or entitled resident to be represented by an approved lay representative in court proceedings in relation to a creditor's application in a repossession case. Secondary legislation prescribes those persons and bodies which may approve lay representatives, and Stephen touched on that this morning. The provisions in the Act essentially introduce the right of audience for approved lay representatives in proceedings related to applications for a repossession. However, it should be noted that the Act does not confer an automatic right on debtors and entitled residents to such representation, nor does it mean that an approved lay representative is obliged to participate in all proceedings. The role of a lay representative. Previously in the repossession proceedings there was a limit to what non-solicitor advisors could do. The only individuals with rights of audience to represent and to participate in the proceedings were solicitors or advocates. The provisions in the Act mean that lay representatives have the same right of audience as solicitors and advocates, so that any debtor entitled or entitled resident involved in these proceedings can have a lay representative acting for them if they so choose. The legislation defines the term lay representative for repossession proceedings with a view to both protecting the debtor or entitled resident and ensuring that court business proceeds smoothly. Only individuals who have the appropriate skills and knowledge to understand the proceedings and to represent individuals effectively should be approved to act as lay representatives. Someone who does not understand the relevant court proceedings or legislation is not likely to be able to represent the interests of debtors and entitled residents properly in court. Other people, such as a friend, spouse or colleague, can in some instances attend court proceedings to support individuals, but this is distinct from the active role of statutorily defined lay representative, and they will not have rights of audience to participate in repossession proceedings on behalf of the individual. So Gavin's uncle Bill can come along to court, but he won't be able to say anything in front of the sheriff. Only the approved lay representative will have the right of audience. Satisfying the sheriff that you are competent to be a lay representative and authorised to do so. Section 7 of the Act requires that an approved lay representative must, throughout the proceedings, satisfy the sheriff that he or she is a suitable person to represent the debtor or entitled resident, and that he or she is authorised by the debtor or entitled resident to do so. In line with this requirement, an approved lay representative will need to be prepared to demonstrate to the sheriff that they are competent and authorised to appear before the court as a lay representative. Prescribed bodies approving lay representatives should ensure that those individuals approved to act as a lay representative are aware that the sheriff is responsible for ensuring efficient use of court time. This means that if the sheriff considers that the lay representative is not a suitable person to act on behalf of the debtor or entitled resident, and therefore that it is not in their interest for this person to continue to represent them, then the sheriff may discharge them from their duties, and they would no longer be able to take part in the hearing. However, I think that's a very extreme case. In my experience, courts generally welcome any assistance which lay representatives can give to enable the court to make better informed decisions, and I'm sure that lay representatives will be well received in the sheriff courts. Thank you very much.